Thank you all for coming to our event this afternoon, and hopefully you'll all be staying this evening. You know, in 2021, the National Security Commission for Artificial Intelligence issued a report. I know many of you probably read that report regularly, but if you haven't, let me tell you that the report stressed the importance of AI and other emerging technologies as national security assets. National security assets. And the Commission warned that China's determination to become the world leader in technological innovation. And of course, by extension, the Chinese interest in this was for economic as well as military dominance. And the bone-chilling passage in that report that I quote for you today is this, quote, China is both leveraging and exploiting intellectual property and intellectual property policies as a critical tool within its national strategies for emerging technologies. Well, I hope I got your attention a little bit with that quote and that report, and I welcome you on behalf of the Eagle Forum Education and Legal Defense Fund. My name is Ed Martin. I'm very proud to serve as the president. Later tonight, you'll hear from John Schlafly, Phyllis Schlafly's oldest son, who is himself an engineer and a lawyer, and he'll have a chance tonight to speak with us. It's such an important issue, patents, the patent system. We often go back to a speech that Phyllis Schlafly delivered in 1988. She didn't deliver the speech at a rally for the pro-family movement, although she considered her and her Eagles as founders of that. She didn't deliver it at a pro-life movement or a movement on any kind of gathering on judges. She delivered this speech, which is entitled How American Inventors Changed the Way We Live, Economic Freedom, the Key to Prosperity. The address was delivered at the Daughters of the American Revolution's National Defense Evening on April 21st, 1988. She was the chairman of the National Defense Committee of the Daughters of American Revolution and advocated on these key issues, including the patent system. So we believe this is a very timely, a vital topic. We believe that having our conference this year under the title Strong Patents, the Key to Our National Security, is not overstating it. So let me say first, we have great sponsors every year, and we're so grateful for their support. They come in so with such ease and such graciousness and such support. The Acacia Research Group, the Biotechnology Innovation Organization, the Innovation Alliance, InterDigital, and PhRMA. We thank you all of you and your representatives that are here for the support. At the end of the panel program here today, we will make a special presentation of the Phyllis Schlafly Friend of American Invention Award. We'll also do a presentation at this evening's dinner, and we're so excited about that and continuing the work. Our offices are just off of Capitol Hill on C Street. We call it the Phyllis Schlafly Eagles Safe House. We're 2 doors down from Mitch McConnell's home, so we have constant security all the time, round the clock, so you can be very safe. But in all seriousness, some of you have utilized the space. If you need it, we'd love to be a resource for that. So let me introduce our panel moderator to lead us through, and our colleague with the Eagles, Jim Edwards. He is our patent policy advisor. He was an indispensable help to Phyllis while she was alive and until she passed in 2016. And he has worked on these patent issues since 2008. He's worked with all of us and many of you on educational opportunities to teach people what's happening, on legislative and policy analysis, and on sharing assessments with Congress and our federal agencies and the public. We all know Jim well here, I hope, and we thank him for all his great work, and he'll lead our panel. So thanks. Jim Edwards, please.
Thank you, Ed. Welcome, everyone. Let me invite our first panelists to come up. Laurie Self, Joe Allen, and Ann Pritchett. Yeah, the order in which I said, you, Joe, and Ann. Well, you can sit there, speak you there.
We're already off script.
Musical chairs.
All right.
Well, our first panel is called Economic Security is National Security, U.S. Innovation and Competitiveness. Hello?
You're on.
Okay. Thought somebody said about turn your mic on. Okay, thank you. Well, at the end of July, Congress enacted the CHIPS and Science Act. It responded to growing innovation and competitiveness pressures coming from China and other nations. The law funds domestic semiconductor manufacturing and research in emerging technologies, such as AI, 5G, energy, and aerospace. Well, this is certainly important, but there's nothing in that law that strengthens our patent system. And patents are vital to R&D and manufacturing and cutting-edge technologies. U.S. innovation advances U.S. competitiveness. For that to happen, patents must secure rights in innovations. Well, Congress knows that knows what the Ronald Reagan Institute Task Force on the 21st Century National Security Technology and Workforce said. That's a long name for a group. It said that China intends, quote, to lead the world in cutting-edge technologies that might allow it to leapfrog the United States, both economically and militarily. Congress hasn't yet addressed the patent piece of this. Oh, I should have said after militarily, close quote. Apologies. The House Republican Study Committee wrote legislation that's related to competitiveness. It's called the Countering Communist China Act. It includes important patent measures, including PTAB reforms from the bipartisan Stronger Patent Act, Stronger's injunctive relief provision, the Donalds-Scott anti-TRIPS waiver language, and a consent requirement for certain PTAB defendants. Well, this is good legislation to build on with respect to where the CHIPS and Science law ends. But currently, it's simply a bill on Capitol Hill, just a proposal by the minority party in a very partisan U.S. House. So don't expect it anytime soon to see much movement. Well, this panel will discuss how patents and innovation strengthen America's economy, keep our competitive edge sharp, and bolster our national security in the process. They'll focus on U.S. leadership in standardization and standards-based invention, commercialization and technology transfer, and biopharmaceutical and wireless innovation. We'll hear of the importance of patents in boosting U.S. national and economic security. And these panelists will discuss why secure, enforceable IP is important as a tool in our competitiveness toolbox. It's my pleasure to introduce these experts. Laurie Self is Senior Vice President and Counsel of Government Affairs at Qualcomm, one of the country's R&D leaders in wireless technology. Before joining Qualcomm, Laurie was a partner at Covington and Burling and chaired the IP practice group. Joseph Allen leads the Bayh-Dole Coalition. As Senator Birch Bayh's Judiciary Committee aide, Joe was pivotal in writing and seeing the enactment of the Bayh-Dole Act 42 years ago. In the Reagan administration, Joe helped implement this bipartisan bill into law and at the Commerce Department's Office of Technology Commercialization. Ann Pritchett serves as Senior Vice President for Policy and Research at PhRMA and manages and directs policy development, research, and educational efforts. She focuses on the biopharma manufacturing supply chain, including cybersecurity and IP, and works on maintaining U.S. global leadership in medical innovation, prior to joining PhRMA and served at the White House Office of National Drug Policy, and she earned a PhD at Virginia Tech. So they'll speak in the order in which they're introduced, and then we'll take Q&A at the conclusion of the three prepared remarks.
Okay.
Laurie?
Can you hear me okay? Yep. So thank you, Jim, and thank you, Ed, and it's a pleasure to be here. So let me just begin with a very quick overview of who Qualcomm is. As Jim said, we are essentially an R&D factory. We have been the R&D arm of what is now a flourishing mobile industry since our founding in 1985. At the time, we were a disruptive startup that had what proved to be a groundbreaking innovation in how you transmit what at the time was voice data through spectrum. And with each generation of cellular technology, it's been our R&D that has driven these paradigm shifts into a world, a 5G ecosystem where everything, every vertical, every industry, every part of our society is connected through cellular technology. And of course, during the pandemic, we experienced the critical importance of that connectivity in a very real way. In 1985, we did not have a product. We did not even know if our technology was commercially viable. It certainly was not accepted in the industry. What kept us alive was a patent system that allowed us to attract investment to protect our inventions as we navigated what was very treacherous terrain for a startup. And that's a dynamic that has always existed in our startup economy. So when we talk about emerging technologies that today are at the forefront of the technological race with China, with national security conversations, as a nation, we have to appreciate that we cannot lead that race without a system of patent rights that incentivize and protect disruptive innovations. That is what has allowed us as a country to succeed in these critical technology spaces, and that is not a dynamic that will change. If we lose that startup disruptive competitive edge, we've essentially lost the innovation game. So just to build on some of the comments that Ed and Jim made, today there is no daylight between economic security and national security. The two are inextricably linked. Countries like China have recognized that for decades. There are parts of the US government that recognize that, but unfortunately, I think our policies in the innovation space are dangerously fragmented. And the reference to the CHIPS Act is a good example of that. That was an important piece of legislation, but we cannot mistake subsidization of any particular sector, no matter how warranted, as an innovation policy. Unless you have a policy that at its heart is based on property rights, patent-based incentives to incentivize research and development, particularly within the private sector, you do not have a coherent or effective innovation strategy. And unfortunately, we continue to have this debate time and time and again. No matter who's sitting in the White House, there is this blind spot in U.S. policy in not recognizing that without a strong patent system, you cannot have a coherent, effective innovation strategy. So today, unlike in the 1950s, the vast majority of technology that's critical to national security is being developed and funded by the private sector in market-based economies. In contrast, in China, you have a subsidization model where national champions like Huawei do not have to generate their own revenue to subsidize or to fund R&D. And that is a critical distinction. Now, apologize. From our perspective, the fact that we have a democratic system of innovation is a strength, not a weakness. We would never advocate for a top-down model of subsidization, but that democratic system of innovation works only if you have a strong system of patent rights. So when we think about the nexus between R&D, standards, leadership in technology-dependent industries, it all traces back to that R&D position. And again, for private companies, the handful of private companies that fund the vast majority of R&D in these critical spaces, we cannot succeed, we cannot run faster without a strong patent system. So I think for today's conversation, that is for me, the top takeaway. No matter what good, Congress does in terms of the semiconductor industry, AI, other technologies, unless there is a laser focus on maintaining a strong patent system, I don't want to say those other policies are irrelevant, but they ultimately are undercut by our inability to maintain that R&D investment position. So I think I'll stop there, but happy to answer any questions as we move forward.
Well, thank you. Can you hear me okay? First of all, I want to thank the Eagle Forum and Jim for having this meeting. What a concept to have actually people in person as opposed to a Zoom thing. Can you hear me now? I just want to tell you, I'm really proud of myself because I actually remember how to tie a tie, which has been a long time since we had to do that. I also want to say that they've got Woody here in front of us. Can you put your hand up? Woody is larger than me. And Woody's got a sign that says stop. And when Woody puts a stop sign up, I'm stopping. So if I stop in mid-sentence, you'll know that I'm deferring to Woody. But I appreciate this. And we do want to be brief in our opening statements. As Jim said, I was on Senator By's staff 42 years ago. I actually had brown hair at the time. And one thing about being a veteran, a grizzled veteran, is I've been through this before. When I first came into when I first got on the Senate Judiciary Committee, it was a very much anti-patent atmosphere. And I'm afraid that we're actually in danger of forgetting the lessons we learned at a very great cost in the 70s and 80s that, again, people are just sort of assuming that because we're number one, because we're prosperous, we can just do anything we want and that'll happen. And that's happened before. And after World War II, the U.S. was the only functioning economy. We dominated the world. We couldn't help but dominate the world. And we had an obligation to help other people get back on their feet, which is laudable. But part of that was people said, okay, well, we need to give our technologies away because that'll be fair. And at the same time, we really thought, who's going to compete with us anyway? Well, in the 70s and 80s, we found out that Japan and Germany were competing with us, and they were starting to eat our lunch. And Birch Bayh was a Democrat, and we worked with Bob Dole in an election year, and Bayh and Dole didn't agree on very much. But what we found was, we thought it's insane to have the taxpayer spending hundreds of billions of dollars on publicly funded research, and nothing was being commercialized. We were shocked. In fact, we found out when Purdue University came to Senator Bayh and mentioned that, Senator Bayh asked me to look into it. And I found out that not a single drug had ever been commercialized from the billions of dollars NIH put into research when they took the invention rights away and tried to make them publicly available. Why? Because the government is not developing products. The government is funding fundamental research. And without the patent system, without somebody taking a risk, they're not turned into products. And we found out that we had 28,000 inventions sitting on the shelf. We destroyed the patent system. And Bayh and Dole said, this makes absolutely no sense. So in an election year, Bayh and Dole got together and we changed that. And so what Bayh-Dole does is it says we injected the incentives of the patent system into government-funded research. We said if you make an invention with government funding, if you're a university or a small company, you own the invention, the government can use it for its own purposes, but you can now either develop it or license other people to take a risk. No one's guaranteeing that risk is going to pay off, but that's got to work better than what we were doing before, which is giving the technologies away. The other thing that happened was two other fortuitous events happened at the same time, one of which was that Senator Bayh was also very interested in the patent system, and after the election, I was running a group called Intellectual Property Owners, and we helped pass the Court of Appeals of the Federal Circuit. Because before then, actually this might have been a good thing, but before then the Supreme Court didn't take patent cases, and the federal circuits had developed sort of on their own different patentability standards. So the Fifth Circuit was strong, the Ninth Circuit was weak, and basically people lost confidence in the patent system. The other thing was that the Supreme Court did take the Chakrabarty case. which said that now you can patent biological materials. So with Bayh-Dole, Chakrabarty, and the CAFC, we had an explosion of innovation. The Economist Technology Quarterly said that Bayh-Dole was the most important law passed in the past half century, quote, more than anything else, it helped eliminate America's fall into industrial irrelevance. So now we lead the world in commercializing federally funded inventions. China's copying our model, Japan's copied our model. I mentioned we had 28,000 inventions on the shelf benefiting nobody. Today, because of under academic inventions under Bayh-Dole, we start 3 new companies and commercialize 3 new technologies every day of the year. No other country's close to that. We lead in every field of technology. Our universities and our federal laboratories work with the private sector, and putting those two together is a combination that can't be beaten. Unfortunately, we're back to where we were back in the 50s and 60s, where now people are taking that for granted. And we have an attack on the patent system. And I'll have to say that the Eagle Forum and Jim have been some of the staunchest defenders where we've had to weigh in to fights which are not pleasant to do, because a lot of times the media doesn't understand these. We're being accused of being unfair, unsympathetic to people that are suffering. And we're saying, no, you don't understand. If you destroy the incentives, everyone's going to suffer. Someone has to take the lead. There's a reason why we lead the world in creating new technologies, and particularly life sciences, is because we give incentives, and by far the majority of the times companies are going to lose their shirts. We just had the Bayh-Dole Coalition just had a webinar with 4 entrepreneurs, energy entrepreneurs, and talked about what it's really like to run a startup company, because you never hear this. One of them talked about it took them 4 years to get a prototype that VCs would even, before they even look at it. Another one didn't have a salary for 2 years. One talked about what it's like to have to lay off your staff the week before Christmas because you can't get funding. No one talks about that. But the reason they do that is because the patent system gives them the fuel of interest to the fires of genius. And if you ever walk by the Commerce Department, where I used to work, if you look on the side of the building next to the White House, that's actually engraved up on the top of the building. And I was walking by there once with Don Banner when he was the patent commissioner for Jimmy Carter. And he looked at that and said, you know what? It doesn't say that we're guaranteed to always have that. And we're forgetting that right now. So what's happening now? You're having the patent system under unprecedented attack. We've got people trying to misuse Bayh-Dole to say the government should set prices if somebody commercializes their product, which turns Bayh-Dole on its head. Bayh-Dole decentralized technology management out of Washington to the people who are actually controlling the technologies. That would put Washington in the driver's seat like they've never been before. That if you were dumb enough to commercialize a technology, anybody could say, I don't like your price, and if the bureaucracy agreed, they'd give it to somebody else. That just doesn't work. The other thing is, I got to go fast. The other thing is we have the administration has agreed to the TRIPS agreement, which has basically said we're going to give our COVID technologies away to developing countries, including China, even though the world is awash in vaccines. And we also have people saying we should use Section 1498 to take people's inventions away if they're too important and have the government just seize them. So again, we've got to relearn the lessons of the past. We can't assume that kids on Capitol Hill now know those lessons. So we need to work together and really tell people the patent system is critical to our future. And if you doubt it, we'll find out pretty soon if we keep going down the path we're on right now. Thank you very much. And Woody had put up one card, but he didn't get me the red card, so I'm stopping.
I don't know if that's a challenge or a threat for me. I'm going to join my colleagues in thanking the Eagle Forum Education and Legal Defense Fund for hosting this discussion. This is a really important topic. I hope this is just the start of an ongoing conversation, given we all acknowledge the critical importance of these issues. I am from the Policy and Research Department, so that means I'm going to throw some numbers at you, and I've got my little cheat sheet to make sure I have them accurate. Just wanted to level set that IP-intensive industries are the drivers of the U.S. economy. 41% of our U.S. GDP and 1/3 of our workforce is from IP-intensive industries. R&D investment is a key determinant of IP intensity. When you look at IP-intensive versus non-IP-intensive industries, you see that IP-intensive industries have much higher rates of R&D investment, 12 times. Higher rates of job creation. There are about 58 million jobs that are directly due to IP-intensive industries. Higher wages, higher dollar value in terms of exports. Strong IP rights are what really underpins U.S. innovation leadership, economic leadership, and as you've heard from my colleagues, economic leadership is national security. So just to turn to pharma, since 2000, our member companies have invested $1.1 trillion in R&D. In 2021, $102.3 billion. So that's an example of how certain industries, IP intensive, that are really economic drivers, are able to weather economic downturns. $1 in $5 of revenue from biopharma is devoted to R&D. That's one of the highest R&D intensity ratios of all industries. And speaking of global leadership, the U.S. currently leads the world in terms of global R&D related to pharmaceuticals, with about 4,500 medicines in development in the U.S. out of a global total of 8,000. But to the points made, our competitive edge is under threat. China and other countries, they are making the investments, they are imitating the systems that we've had in place for decades. So while they're looking at what we put in place, we're kind of looking at eroding what we've had in place, and we can't afford to do that. We have to keep up. Our industry also generates $1.4 trillion in economic output, and we have a high job multiplier, so we support about 4.4 million jobs across the economy. And we've got about 1,600 facilities across the U.S. and U.S. territories, and that continues to grow. And, I'll hit on this again. Strong IP rights really underpin our innovation leadership, promotes free market competition, and fuels our economic security. Intellectual property rights, particularly patents, they are designed to, and they both foster innovation and competition, which we know is critically important. And IP is really critically important to our sector because of the unique aspects of our R&D. It takes us 10 to 15 years to develop a new medicine. It can cost on average of $2.6 billion. And we have, frankly, high failure rates. We're engaged in areas of high scientific risk where there's a lot of uncertainty, and we need to get as many shots on goals to make progress. And we have an approval rate of about 12% at FDA. And another important attribute is that, just as you heard from my Qualcomm colleague, from Laurie, R&D investment, doesn't stop when you get a product to market, it continues. And for us, post-approval indications are fueled by the ability to patent to protect that invention the data for a certain period of time. So that's new uses in different disease states, different dosage forms, new delivery forms, all critical to not only expanding treatment options for patients, but increasing competition on increasing brand-to-brand competition. And then, of course, unique to our sector, we have these long-standing statutory frameworks that have incentives for innovation, but that's balanced with streamlined regulatory approval processes for generics and biosimilars. And generics are 91% of the scripts filled in the US, and it provides about $2 trillion in savings. And biosimilars it's a robust and growing market, and we need to make sure that we're fueling that life cycle and those types of innovation and competition. Just to shift gears slightly, there's a little bit of mention about, for some people, first time on a plane, getting to in-person meetings. And yes, you're welcome from the pharmaceutical industry and our hundreds of partners around the globe. For me, the COVID pandemic, it's really underlined that economic security, national security, and public health are deeply connected and intertwined. And contrary to what some have alleged, IP protections are what enabled our sector to enter into hundreds of partnerships around the globe that allowed us to identify manufacturing partners based on our technical requirements, that really provided us the ability to get as many shots on goal as possible so that we could research, develop, manufacture, and distribute vaccines and therapeutics around the globe. And that was because we had patents and other IP incentives and regulatory incentives that allowed us to make the decades and decades of investments in infectious disease, build our expertise in manufacturing, vaccines, quality control. We were all able to bring that expertise to bear and quickly go through our compound libraries, look at failed projects, existing products, and get new projects underway really quickly. And the end result is that that we've had more than enough vaccines produced and delivered around the globe to vaccinate everyone who wants to be vaccinated. And the economic and national security benefits of these investments are really clear. Mitigation measures, such as being able to avoid the lockdowns and the slowed economic activity, from getting vaccines in a timely manner, it's produced almost $1 trillion in increased economic activity in the U.S. And we got here really because the U.S. has long recognized the importance of a science-based regulatory system and a policy and legal framework that appropriately fosters innovation and supports the range of partnerships and collaborations and tech transfer that Joe spoke to. And as Joe also mentioned, the U.S. has not always been the global leader. Until the 90s, Europe was the global leader in biopharma R&D. But as they started implementing more draconian, suppressive public policies, the scales frankly tipped. But as Joe also said, it's our success and progress isn't assured. And not to steal thunder from the next panel, but misguided price-setting policies, such as those we've seen in the Inflation Reduction Act, they're jeopardizing U.S. competitiveness. They're jeopardizing patient access to new medicines, and it's going to jeopardize our national security. Early estimates are that the price-setting provisions could cost us 600,000 jobs over the next decade, $645 billion out of pharma alone. So that means we could see dozens and dozens of new medicines not come forward. As someone who lost my father-in-law to ALS, I don't want ALS to be one of those innovations that we don't see because of policies like this. And oh, by the way, at the same time, we have an administration that, as we've referenced, is supporting an IP waiver. And that's based on zero data, given we have enough vaccines to vaccinate everyone around the globe that wants to. So we need to be careful about solutions that are looking for problems, and we want to make sure that we are all working to educate on the importance of intellectual property, the value of it, and debunking the myths that are out there. All of this to say, if America wants to maintain its economic strength, resiliency, and competitiveness, we all have a role to play in maintaining and advocating for U.S. continuing its leadership and innovation by continuing to protect IP through sound policies. And with that, I'll get off my soapbox for discussion. 2 seconds. Oh, see? Yeah. I'm a winner already.
They're running their own tight ships. Thank you all. I'm going to stand up so as you raise hands and so forth for Q&A. We're going to do 5 minutes of Q&A, Woody, so put the process in motion, and I'll be on the lookout for you for my hook. If you would, please, if you have a question, identify yourself by name and your affiliation. I appreciate that. Richard.
Richard Laurie with InterDigital. Joe, I've got a question for you. You spoke about Bayh-Dole being passed after a period of great sort of hostility around IP rights, which obviously is parallels to where we are today. Were there any messages then when you speak to stakeholders, maybe other legislators who might be skeptical of the legislation, that kind of helped bring them round, particularly in relation to patent rights?
Yeah, and it actually wasn't me. What we had the state universities were really very effective in talking to the people from the different states, because it's hard to imagine now, but before Bayh-Dole, you didn't have companies investing in university research for a simple reason. If the government had funded any research there and an invention was made, they would take it away. So what we had done was we had segregated our best and brightest minds in the public and private sectors so they weren't collaborating. And I think that really resonated with a lot of people. So I remember Senator Bayh was on the floor one day, on the Senate floor, not on the floor, sitting in his chair on the floor. And I went down as a young staffer with some good news, and I said, we just picked up 2 new co-sponsors. We picked up Senator Kennedy and Senator Thurmond, Jim's old boss. And that was like if you picked up Elizabeth Warren and Ted Cruz. And Bayh, I'll never forget, he looked at me, he had his reading glasses on, he says, "Are you sure this bill makes any sense?" And we both had to laugh, because that just didn't happen. But I think that's really why we were able, and plus Bayh and Dole were so well respected on the various parts of it. But that really broke it. But the other thing that we shouldn't forget is we had a determined opposition, which has never gone away. And they've been fighting Bayh-Dole for 40 years. They make the same arguments, and unfortunately, those arguments resonate with the media because they don't really have any context. And the argument basically is, all this innovation would happen if we just put it out in the public sector and let it flow. The patents are bad, they're really hurting competition, they make things more expensive. There's no data on that, but unfortunately, that's an easy, and also the public's being exploited. Well, unfortunately, that resonates with people, so we're always having to explain ourselves, but it was really because of the university and small businesses that took the lead on it that we actually overcame that. And it was very close. We almost didn't do it.
President Knoll, Tradition Family Property. If patents aren't protected, what incentive is there for anybody to create something new?
I'll start. I mean, look, I think this is part of the sort of narrative that Joe was speaking to, this notion that, well, of course people will innovate. We're creative by nature. It's part of being, being human. And of course, what's missing in that conversation is, yes, of course, we all on a daily basis might have good ideas, but the kind of hard work of bringing ideas to fruition, to creating something that's actually capable of being commercialized, that has economic value, that's where patents obviously play a critical role. And one of the things that I find really frustrating with the narrative that Joe was referencing is that if you look, there are economists, economic historians who have looked at the effectiveness of different so-called incentive systems. So what we have in the United States, which was revolutionary at the time of our Constitution, is a democratic system of patent-based property rights. What we see in other countries, China, a subsidization model. Of course, we've all heard about prize systems. None of those systems are as effective as a patent system in creating a truly democratic system of invention, where everybody in the country has that opportunity to become an inventor, and through a system of property rights, through a system of private capital, through a market-based economy with a rule of law, you have an opportunity to actually create economic value through that inventive endeavor. So I think as we look at this dynamic of why are we fighting these same battles time and time again, I think in part there's a very organized lobby in all of these different sectors we're talking about. In the pharmaceutical, biotech sector, it's one lobby. In my sector, it's the big tech companies. But the facts are that, yes, there are other systems of incentives, but they don't work nearly as well as a property-based system.
One more question. Bill?
So, hi, Bill Rickman at Covington. So mine's a little bit not necessarily what people have addressed, point out, but I know many of you have thoughts on this. So there's the question of what's good for the economy, that's good for national security, what's good for consumers, but how about what's good for inventors and what's good for human flourishing? Because it was Edward Phelps, the Nobel Prize winner, who said that, in fact, the reason to have strong patent intellectual property protections is not principally because of the benefits that accrue to prosperity, though they do, but what it means for human flourishing and what kind of society it is. Soviet Union, you invented a cure for cancer or a new way to open a bottle. You got 10 rubles no matter what you invented, right? So there was no incentive really for that kind of risk and invention. What does that mean for human flourishing? I leave that open to anybody on the panel. I know Laurie and Jim have both thought about such things, but others have as well.
I think I'll just comment that, one of the things that's great about the U.S. is we are viewed as the kind of birthplace of entrepreneurship. VC flourishes here. Startups are starting up every day. There are always more emerging companies. That's, kind of what our personality, that's in our DNA, and I think that's critically important. It is who we are, that we are inventors, and we're proud of it. And there's always an opportunity to invent something better, develop a better process, develop a better medicine. And that benefits everyone over the long run. And I think that's a really critical aspect that, again, speaks to how we need to be doing a better job of collectively telling our story of all the ways in which IP kind of makes us who we are as a country. Particularly as, to your point, we're facing competitor countries who, have very different values and views. And so it's important for us to kind of remind as to what our country was founded on and what we all collectively believe in.
Thank you. And thank you, panelists. Moving from economic security is national security to the next panel, protecting the crown jewels, institutional keys that guard America's IP. So next panel, please come up.
Wait and see in which order he comes.
Yes.
Brian Pomper,
It's like a beauty pageant.
Hans Sauer, Brian Dorini.
What's your talent, Brian?
Excellent question, Laurie. I have to think about that.
Well, the U.S. has steadily weakened our patent system, as we've heard, and patent rights in recent decades, unfortunately. And meanwhile, China is playing to win. Well, by 2020, China has outspent us, the U.S. on R&D and passed the U.S. in patent filings, according to WIPO. The AI Commission, which was quoted earlier, cites China's strengthening IP system. It allows access to injunctions and meaningful damages for IP infringement. China has copied our Bayh-Dole Act to facilitate the commercialization of its university inventions. China uses quotas and subsidies, as Laurie emphasized, to incentivize patent filings and gives rewards for patent grants. Its scale of patent applications, quote, dramatically increases the quantity of prior art that must be reviewed in examining a patent application, end quote, and that's from the AI Commission on National Security. Well, also China over-declares its patents as standard essential. It alleges that these patents must be practiced to comply with a technical standard. And China's copying and stealing still. So how can we bring it to bear the specific assets of our innovation system? That's what this panel looks at. Federal courts and the U.S. International Trade Commission are bulwarks against patent infringement. They promote such remedies as injunctions and exclusion orders. The TRIPS agreement promotes respect for patents and IP rights internationally. Well, it's a little caveat now to that, but otherwise promotes respect for patents. The TRIPS is now before the World Trade Center. As you know, it's waived for COVID vaccines, and the question now being discussed is with respect to therapeutics and diagnostics. So we'll hear about that as well. And of course, the Bayh-Dole Act facilitates technology transfer wonderfully from federally funded research. And standard essential patents and merit-based standardization play important roles in technological advancement. So let me introduce the panelists who will discuss the roles these crown jewels of our IP system play in U.S. security. Brian Pomper, my friend, is Executive Director of the Innovation Alliance, which is a coalition of leading research and development companies. Brian's a partner at Aiken Gump, where he co-leads the firm's public law and policy practices. Brian's a registered patent attorney, and he served as Chief International Trade Counsel at the Senate Finance Committee. We have another panelist who will be joining us as soon as House voting is concluded. He will run in and join us and give his remarks. Congressman Byron Donalds. He represents Florida's 19th Congressional District. He was elected in 2020. He is sponsor, along with Senator Tim Scott, of the Preventing Foreign Attempts to Erode Healthcare Innovation Act. And he says of H.R. 3035 that it would prohibit the Biden administration from giving away the fruit of American ingenuity to foreign adversaries and putting at risk global health in the face of a pandemic. So his bill would block U.S. support at the World Trade Organization for waiving IP protections for COVID technologies. Hans Sauer is Deputy General Counsel and Vice President for Intellectual Property at the Biotechnology Innovation Organization. Hans advises BIO's Board of Directors, amicus committee, and staff committees on patent and other IP matters. Before joining BIO, Hans was Chief Patent Counsel for PhRMA and Senior Patent Counsel at Guilford Pharmaceuticals. And in addition, he holds a JD and PhD in neuroscience. Brian Dorini is Director and Senior Standards Counsel at InterDigital. Brian focuses on issues at the intersection of standards and patents for InterDigital's entire IP portfolio. He has extensive experience creating and implementing strategies to build and leverage a SEP-rich patent portfolio. Brian was previously partner at Fish and Richardson and clerked at the Federal Circuit. So please welcome our panelists, and they're going to speak in the order in which they are sitting, which is the order in which they were introduced.
Well, thanks, Jim, and thanks for the invite to be here. Always good to see all friends and learn things. So Jim asked me to talk a little bit about injunctions and also the International Trade Commission. Now, why do those two go together? Well, I'll explain that maybe a little bit as I go forward. But first on injunctions, this, of course, is the primary remedy, or should be the primary remedy for patent infringement. What does a patent give you, right? Who can tell me? What does a patent give you? The right to exclude. Laurie, you get a gold star. That's right. You know, I think lay people who don't focus on the patent system, I would call non-patent dorks. Like, we are all patent dorks, by the way, so proudly embrace it. You know, they think a patent gives you the right to use a technology, right? And that is, of course, exactly what it does not do. It gives you the right to exclude others from using that technology. If that's what the right is, but you can't get an injunction from a court to prevent somebody from using your technology, what actually does a patent give you? I mean, I asked that question earnestly because I don't know. I'm not the first person to make that point, but it is a little bit of a Gordian knot puzzle. Used to be that injunctions were readily available to patent owners in the United States, as they are now, certainly in Germany and China and other countries, until 2006. Famously, the Supreme Court decided a case called eBay versus Merck Exchange. And in that case, and I saw Adam Mossoff here, my teacher on this, as in so many other matters. You know, I puzzle over this case, eBay, because it felt to me as I read it that the court was conflating the idea, this equitable remedy of a preliminary injunction, something you get right away, quickly, with the permanent injunction that all patent owners really should get by right if their patent is infringed. Otherwise, basically, it's a compulsory license. Right? You can't stop somebody from using your patent, and really then you're just arguing over the price. But of course, if you can't stop them from using your patent, boy, that price is going to be pretty low, seems to me. So I asked Adam this. Adam, doesn't it feel like the court is conflating these two standards? And Adam said, of course. That's exactly what the court did. And even worse, the court there was the majority opinion by Justice Thomas. There was the concurring opinion by the Chief Justice, who, kind of trying to put his thumb on the scale, said, yeah, I guess I agree with this majority opinion, but keep in mind that injunctions have historically issued almost always, and really we should continue to follow that practice. But Justice Kennedy issued a concurrence where he said, you know, the truth is everything is different now. In this modern era with technology and the internet, everything is sort of different. And so really it feels like maybe there really shouldn't be injunctions given quite so much any longer. I sort of point that out because, unfortunately for all of us in this room, the lower courts have really adopted that Kennedy concurrence, and they focus on that. Now look, many of you know I'm a Democrat. I wouldn't call myself a conservative. I'm moderate. I'd say I'm a moderate. Many of you are conservative. Jim's conservative. Bill Wichterman over there, he's conservative. Got lots of Eagle Forum's conservative place. Yeah. I always felt like conservatives, I think conservatives you should be skeptical when somebody says, you know what, everything is different now, and we've got to do something completely opposite from what we've always been doing because everything is so different and we got to do this now, right? Like that feels like a conservative approach to me. But unfortunately, this is how Justice Kennedy did it. Everything is different. We got to just throw everything we've done out previously out the baby with bathwater. We're going to never issue injunctions anymore, and that's how the courts have really interpreted it. So it is much, much harder for companies to get injunctions today. It's not impossible, but it's a lot harder. And it's especially hard for companies that focus on developing inventions and then licensing their inventions to all comers, as InterDigital, of course, does, and Qualcomm does in a large measure, and others. So we're sort of left in the circumstance where these companies, which are the most innovative of companies, they're invention factories, right? These are companies who the bulk of their employees are engineers who come to work every day to think of the next cool idea that they can patent and then license to everybody. Those people have a very hard time getting injunctions and therefore are undermined. So it's a terrible state of play on injunctions. Okay, so then let's talk about the International Trade Commission for a minute, because I think often people conflate injunctions with the International Trade Commission. In fact, when many of us in this room worked on the American Invents Act, when it passed in 2011, we sort of said, oh, whew, boy, that was tough. We sort of avoided maybe the worst of all possible words in the EIA. We can sort of relax now and work on implementation. And I swear to you, within less than 12 months, the forces of darkness and evil in the big tech world had a new bill to undermine the International Trade Commission. And they did this in such a way, they wrote the bill in such a way, a bunch of former Judiciary Committee staffers wrote this bill. Now, as Jim said, I worked on the Senate Finance Committee. I was the Chief International Trade Counsel for the Senate Finance Committee. The ITC implements Section 337 of the Trade Act of 1930. That's really what we're talking about here. This is the kind of patent litigation before the ITC. It is a trade remedy. Let me repeat that. It's a trade remedy. It is not a court case about infringement. It is all about a good coming into the United States. Does it infringe U.S. intellectual property or not? In fact, these cases, they're in rem cases. They're not in persona. They're not, party X versus party Y. They are in re set-top boxes from China, right? I mean, it's all about the good. And I think that the folks who have tried for many years now to undermine the International Trade Commission to make it easier to import infringing articles from China, they've never understood that. You don't get an injunction, you get an exclusion order, which Jim correctly noted. They have tried for many years to import the equitable side of eBay, right? Making it so hard to get injunctions in court. They've tried to import that into the International Trade Commission, which makes no sense. And in fact, because it makes no sense, many of us in this room have worked for many years to prevent that bill and the ITC from gaining any traction. It has really not gotten any traction. It doesn't keep them from introducing it. So we need to be vigilant on that as well. The last thing I'll say is the International Trade Commission is there, as I've said, to block articles that infringe U.S. intellectual property from being imported into the United States. Something on the order of 80% of those products are coming from China. So whenever anybody wants to talk about making the ITC weaker, weakening the remedy, all that, I just tell them, well, let me just tell you how the way this is going to be discussed. It's that you want to make it easier to import infringing articles that infringe U.S. intellectual property rights from China into the United States. You want to facilitate that. I don't think that's a great political statement, and in fact, I think most people who look at this bill, they're kind of thinking, oh, maybe this looks interesting. Afterwards, they kind of back away from it slowly. So that's injunctions and the National Trade Commission. I'll turn it over to Hans, but happy to answer any questions.
Do I just start?
Please.
Okay, I do it before Woody hits the reset button. It gives me more time. Okay.
I have like 2 seconds left.
It's going to be hard to top, in terms of drawing the audience in. So let me start by confessing that I was in Ecuador when this group had its prep call. So I'm going to improvise a little bit, and in the course of doing so, I may repeat a couple of things that you already heard from Anne and others, but I do believe it's worth hearing at least some of these. But maybe I can start by saying when I started doing this for bio, right, or even before when I started going to law school, and I was wondering, well, who makes patent law in the United States? Well, who is it? Who makes these laws? And you heard, well, it's the Supreme Court and the judiciary that really makes most of the law. And having grown up in Europe, it's a strange thing to think about, like the power of the judiciary in making operative law. It felt like a not very democratic way of making decisions about IP policy and shaping the law, because court cases are between self-interested litigants and very smart lawyers and judges that have lots of other cases going on, and boom, before you know it, you have a case like eBay, right, that changes the law forever, and there's no way to reverse that short of an act of Congress or a constitutional amendment. Very odd way, I thought, of making law. Who else makes patent law? Well, there's Congress, but who in Congress? The Judiciary Committee? I said, really? Because patent law, it's really like commercial law, right? It has to do with trade, with innovation, with science. Right? Shouldn't it be in the Commerce Committee or whoever deals with trade or whoever deals with science? No, it's in the Judiciary Committee, where the committee members otherwise concern themselves with appointing judges or civil rights, these kinds of things. It feels like, I don't know if it's the right kind of place, but for better or worse, we have a great patent law in the United States, at least from my perspective. It's just been changing a little bit too much, a little bit too fast, and in ways that feel a little bit out of control, because patent law, I want to say this again, I think is commercial law, and it serves a certain purpose, and it's embedded in an economic vision in the United States, where again, I didn't grow up here, but an economic vision that seeks to leverage private investment, that values private entrepreneurship, and where public money too is being spent on research and innovation, but it's spent in a way that leverages and recruits private capital, many multiples of private capital investments to come to fruition in, I think, some sectors where the U.S. really leads. Brings me to the crown jewels. So Anne explained a little bit about the industry that we come from, right? I represent a slightly different segment of the industry. I represent bio, which is mainly small biotech companies. But here goes, right? Why is biotech, in my view, one of the crown jewels? Well, for at least 2 decades, and I will just re-emphasize this because you heard it from Anne, the U.S. has been the main global originator of new drugs and new therapies. In a field once dominated by Europe, US-based researchers have long invented more new drugs than the rest of the world combined. Well, it's not just that we invent most, we invent more than the rest of the world combined. A recent bio-funded study of the 338 new drug molecules approved between 2011 and 2020, so it's really recent, found that fully 2 out of 3 new drugs were conceived and developed in the United States. More than half of these were invented and developed by small entrepreneurial companies. Small companies also edged out large companies and public institutions in IP creation. There are many palpable benefits for American patients, consumers, and workers that flow from this. So, for example, new drugs become available in the United States, often years before they become available in other countries. U.S. biopharmaceutical businesses, large and small, support 4 million well-paying domestic jobs. Surely we've done something right. Yet such benefits come at a cost, right? Leadership just isn't for free. And it is true that industry spends in excess of $100 billion of private capital every year in R&D in the biopharmaceutical space, and the government, largely through the NIH, contributes another $40 billion in basic biomedical research funding. Right? No other country in the world invests this much in biomedical innovation. In the US, it amounts to fully 8% of total healthcare expenditures in the United States, which go to pay for innovative prescription medicines, right? The fruits and the products of these research investments. 8% of total healthcare expenditure is a lot of money, 8% of $4 trillion. Right? That is a lot of money that flows back into the industry to pay for these products and to fund the next generation of innovative products. The US system has long been willing to pay for innovation. The US system emphasizes access to all drugs, unlike other countries where they have tiered formularies and patients only get access to some drugs but not others. Right? The US is unique in that sense as well. The fully capitalized investment to bring a new drug to market approaches $3 billion, according to by our count. And you heard it from Anne, the likelihood of success is only around 10 to 12%. So that's an almost 90% failure rate over about a decade of development. Right? So it's a steep order, and it's been very productive. But there are misgivings among policymakers. Perhaps all this innovation comes at too high a cost. We have eternal discussions about why should we in the US be paying more for new drugs than other countries do. I'm going to speed this up a bit. Under recently passed legislation, the Build Back Better law, right, it's expected that the cash flow, the available cash flow of a lot of companies, many companies will be reduced by 50% or more with proportionate decreases in investment in new R&D. There's no question at all that dozens and dozens of therapies will be shelved and not be developed, and capital will flow elsewhere. The situation, the investment situation for biotech right now is actually fairly dire. I'm winding down to my last 30 seconds. The biotech sector is underperforming the broader markets by a wide margin. Markets are down, there's a lot of risk, but biotech is faring very poorly right now. There's been an exit of capital. This is a very bad time to weaken US patent laws. In the meantime, China, just in the last year alone, launched about 95 venture-backed biotech companies. And this is my signal. They are coming for us. They have eclipsed Europe in company formation and investment. They're tracking at twice at what Europe is doing, and they're catching up with the United States at an accelerating and alarming rate. But if we want to protect the crown jewels, keep that economic context in mind. Everything that needs to be said about patents has been said, but I want to lay the table for you, at least in this way. They're coming for us, and they really are. This is well documented. And patent law, we'll have more opportunities to talk about that. I'll pass it on. Thank you.
Yeah, great, thanks. So thank you, Jim, and the Eagle Forum. It's a pleasure to be here. And thank you, Brian and Hans. It's great to hear your remarks. I guess I've been asked to try and say a little bit about SEPs. That's the piece of the puzzle I'm going to say a little bit about. For those that might not be familiar with InterDigital and wondering, so why is InterDigital talking about SEPs? Just a few short remarks. We are an R&D-based company. Up the road in Wilmington is where we're based, not just incorporated, but actually based there. And over the 20% approximately of our revenue each year gets funneled back into R&D, so we're well versed in R&D. Lots of engineers, as someone mentioned earlier. And those, all of that R&D produces a lot of patents. That's our primary business model. Current count approximately 28,000, including lots of SEPs. And we take those patents and those SEPs and we license them around the world. Most of the OEMs, by far the vast majority of the OEMs that use our technology, they might not be paying for it yet, but they're using it. They're in China. We also license in Europe, US, elsewhere throughout the world.
So InterDigital understands a lot about, has got an experience at the, the crossroads of law and policy and practical business experience around SEPs. So jumping into it, the first question I was asked to address was generally sort of, how do SEPs relate to U.S. competitiveness and U.S. national security? On the competitiveness front, I think it's pretty straightforward. I won't belabor it. If you've got the patents and you invented the technology and you've got a head start, that's a significant advantage. And that advantage in the standards context oftentimes extends from generation to generation. If you look at the leaders of 2G and 3G and 4G, for example, there's a lot of repeat players, and that's not an accident. On the U.S. national security front, I think people are probably pretty familiar how patents can play into that as well. I mean, there's two flavors of it that come to mind. One is quite direct. If a company's got not just market share, but actual market dominance, industry reliance, the U.S. and its allies might find itself in a position of having to take product from them and then wonder if they're going to be subject to data collection by the government of the company that, from the country where they are housed. Another way national security can be implicated, of course, short of that is just, if you've got market share, you've got a lot of revenue, no doubt, and a lot of relationships. And you could be conducting very legitimate sort of business negotiations with foreign governments that just simply don't end up with solutions that are in the interest of U.S. national security. So I think the takeaway is the U.S. should want the U.S. companies to have a lot of SEPs in their relevant markets. So SEPs are important. There are some dangers, some challenges on the horizon, not just the horizon right here and now. I'm just going to highlight two of them. A lot of them, people have been talking about a lot of them. One of them is enforcement of U.S. patents, and the other, which I'll get to, is U.S. company participation in SDOs, Standard Development Organizations. So on the first one, enforcement, I'll focus actually on agencies. U.S. agencies are actually kind of getting in the way. You might even say they're contributing to a holdout by foreign and other companies. And a couple of remarks were already made touching on some of this, but three quick examples might be the withdrawal of the 2019 Joint SEP policy statement by DOJ, PTO, and NIST, which was, it treated SEPs on a level playing field with other patents. A second example would be just focusing on the DOJ. The previous administration had what they called their New Madison approach. Also treated SEPs on a more level playing field with other patents. It said SEPs should have the right to exclude. It also said that FRAND disputes should not necessarily be considered per se antitrust violations. These are important things, and it was welcome at the time, but unfortunately the current DOJ is walking that back a bit. And then a third example of U.S. agencies and other parties sort of getting in the way would be the FTC's. The chair, Lena Khan, just this year has been trying to get the ITC to limit the availability of exclusion orders for SEPs. So that makes it hard to enforce those patents. But there's another challenge that InterDigital is very familiar with. If you peel it back, say, where do these SEPs come from? Well, you need R&D, of course, but you also need to get that R&D into a standard, and you do that at a standard development organization. I mean, InterDigital creates scores and scores of inventions, but that's not the end of the road. They have to take those to the standard development organization. They have to present them to the other companies, make the case, and essentially prove the case that that's the best technical solution before those things ever end up in a standard and before you ever can get an SEP. And this takes a lot of time, a lot of money, it takes participation, it takes leadership at the SDO, and it's an expensive business function. Nonetheless, for a company like InterDigital, well worth it, but it's expensive nonetheless. And other companies around the world, other countries, they of course know this, it's no secret. But China in particular has been leveraging this well over the past many years. They're playing this game extremely well. It's part of their national strategy around standards, and presumptively supported by the Chinese government from a funding perspective. But kudos to them. They're very strategic. they're playing the game well, and I guess my point is the U.S. should do that also. And in fact, just this month, PTO Director Vidal made the point that we should reinforce and encourage U.S. company participation at standard development organizations. So those are two of the big challenges that I see right here in front of us. I don't want to leave you just with that. So I'll give three solutions. Consider them ideas. We can talk about them later on. The first, welcome change to help swing the pendulum back towards treating SEPs on more of a level playing field, would be some legislation to address foreign company holdout. That would help the enforcement. Second one would be a return to some of these new Madison principles that I mentioned earlier. And the third would be to provide some incentives to U.S. companies to participate in SDOs, and that would make good on Director Vidal's recommendation. So with that, with some time left over, I'll return the floor to Jim.
Thank you, and it's my pleasure to introduce Congressman Byron Donalds, Florida's 19th district. Of course, I gave his full introduction earlier, so I think he knows who he is. I'm going to repeat it for him, even though it was well written, right? But it's a special privilege to have him. He is, as a freshman member, jumped right into this patent space, and for a freshman or anybody in Congress to do that is laudable. We really appreciate his leadership and just want to thank you for coming, and we want to hear about HR 3035 and your leadership on preventing more damage on the TRIPS agreement.
Sure. I'll move this over here. Thanks. First of all, it's good to be with you guys. Sorry for my tardiness. It's Capitol Hill, so it's a little crazy. Look, in short, what we really wanted to accomplish was to stop an erosion of intellectual property in the United States. Obviously, it centers around the COVID-19 vaccines and the IP associated with it, but it's actually broadening around all of the medical technology in that field. In short, the administration's, I think, idea or goal to try to help the world get over COVID quickly was, I can understand why you would want to do that, but at the same time, if you do not protect intellectual property of companies here in the United States, what that ends up being is a slippery slope out of emergency periods into what typically can become standard operating procedures from the federal agencies. They typically have a habit of adopting policy in emergency times and think that it's good for all time. So the purpose of the measure was that, to bring a halt to that. Obviously, under Speaker Pelosi, she basically decides what she wants to go to the floor. And it's a tough legislative process during this Congress. But the thing I wanted to make sure that you're aware of is that there are many members on Capitol Hill, and it's not just purely Republicans who actually are concerned about IP protections. I think this is something where, if we're going to look at the competitive balance of the United States versus China and versus other economies that are growing are going to grow, protecting patents and protecting IP is going to be critical for us. I think that's super critical, as well as, and it's probably not the topic of your point, but it's mineral procurement around the globe, which we are severely lacking and behind. So in short, that's the measure. It was actually something my staff and I started talking about after the president made his announcement, and we're like, well, that makes no sense at all. What can we do? And we make that proclamation a lot in my office after the president speaks. So it was about what are the actual systematic steps we could take. That was the work product that formulated out of that. And now our hope is that in the 118th Congress that we move to make that become a part of law here in the United States. I think from a border perspective, and I don't think we are, but we can't delude ourselves into thinking that we are still the dominant economic player in the world. We are still the place where most people want to do business because, frankly, not many people trust China. They do business with China under duress or basically under force. or economic force, and maybe other means as well. But they want to do business here in the United States. But if we are not serious about patents, about property rights, about protecting IP, about stopping, I'm gonna just use the phrase economic espionage. If we're not prepared to deal with that on all fronts, the Chinese Communist Party and the government and the Chinese government are going to continue to be aggressive, not just within their borders, but as you guys already know, all across the globe. So I think that's kind of the mindset of, that's my mindset, that's the mindset of a lot of the members on Capitol Hill. And so we're going to do what needs to be done to protect our business community and protect our entrepreneurs and our innovators here at home, and even if they choose to do business around the globe. That's it. Guys, I love you. I got to run. Congressional football game starts in like 35 minutes, and I also play a defensive tackle.
Well, that makes it even faster to give this award. First of all, I want to say Byron is not the real politician in his family. Years ago, down in Naples, his wife, Erica, was a school board member and brought along her husband to an event that we did down there with the Eagles, and that was before he had to slum it up in Congress. So she's an amazing lady. And we're coming back to Naples this February, March to do an event, so we'll make sure to include her. Yeah. We'll include her.
No, she can't go anymore.
She can't go at all?
No.
Because why?
Just said
that. All right, John Schlafly, come on up real quick. I know you have to go, but we want to make sure to thank you for everything you've been doing in Congress, but also how you're communicating, playing a role in the Republican caucus, which is important to us. And Phyllis Schlafly we created an award, the Phyllis Schlafly Friend of American Invention Award, that we give each year to someone who's been standing up for this issue, not just in Congress, standing up on the policy side, or Director Yanku, I think, was last year. So we just want to say thank you to you for that and what you did, and that there's a lot of people in here who appreciate how you have been carrying forth the weight on this issue, and will continue in the future. We look forward to having you back again. So thank you very much. Good to see you. And let's take a picture here. Where's Ryan? There we go. John Schlafly, Phyllis. Here, help me, John. Oh, here we go. You take that. Yeah, you got that? Here, come over here, John. Look up. Here. Jim, we need anybody up here? All right.
This one's got some heft.
Yeah, that's what we do. Use it on somebody. Put it in your, tape your hand.
No funny ideas around here. Thank you so much.
All right.
And real quick, John, your mother was a pioneer when pioneers were needed.
Thank you.
Thank you so much for you and your family. Thank you. See you guys.
Well, thank you, Congressman. And we're going to do 5 minutes of Q&A. And since we've got 5 minutes to spare, we'll do that. Remember, if you've got a question, state your name and your affiliation.
Hey, Jim, it's Bart Forsyth with PhRMA. So the air horn cut Hans off when he was starting to talk about the dearth of biotech investments. I wanted to give him a chance to kind of talk a little bit about what you think is driving that, and what effect the IRA and this law changes are going to have.
Okay. I think just look at the environment, right? I think a lot of the awareness about investing in biotech is driven by policy incoherence and worrisome discussions and policy initiatives that are unfolding both on Capitol Hill and within the administration. So look at what the administration is doing, right? On the one hand, it looks like there's a national consensus that innovation is a great thing and we should be investing more in it. We heard about the CHIPS Act. The president signed an executive order about bringing biological manufacturing home, onshoring of pharmaceutical supply chains and the like has long been part of the agenda. We're going to have another cancer moonshot. So all these things are great, but they're happening without any indication that we're, as you said, Jim, trying to strengthen our IP system at the same time. Right? Continuing the theme, we heard it, the administration supports waiving IP rights for COVID vaccines. They're vacillating about giving away biomanufacturing technology for COVID drugs and other technologies. Right, we're bolstering antitrust enforcement to control businesses that are competing quite well in the market for innovation, but where antitrust is being used for other purposes. So lots of things going on that make investors think that they can take their money elsewhere. And I really do think it's puzzling to think about the policy incoherence, especially from my perspective in the biopharmaceutical space right now. And when you peel back the layers of the onion, you wonder whether, on the one hand, we're dealing with policymakers who, yes, they really want innovation and they're willing to invest in it, but on the other hand, they are too suspicious of the private sector. Many of them don't welcome private investment in healthcare innovation anymore, and who maybe have a vision that the public sector should play a much larger role in directing innovation, funding innovation, controlling the products of innovation for the general public good. Right? It's a different kind of vision that doesn't trust markets anymore. And I think that's partly what's playing out, and it's spooking investors. Right? Investors are leaving lots of industries, but they're leaving biotech right now in especially large numbers. We're really in pretty bad shape compared to other technology industries at this point in time.
Another question?
So the other side that, as Brian Pomper calls them, the forces of darkness, have been very active in recent weeks and months, getting a lot of former members of Congress to opine publicly about the need to weaken patents. They don't say that, of course. They talk about national security, and they say how national security is at risk by these, essentially, again, by overly strong patent rights. A lot of these members, I think it's worth noting, were themselves pretty absent from any debates about intellectual property during their tenure in Congress. So my question is, to what extent does the panel see that the other side is making a play to make further changes legislatively or administratively to weaken patents, and what can the forces of light do against that?
So I'll kick it off quick. So yeah, my joke, and many of you have probably heard already on this, is a lot of those members don't know how to spell IP, right? They have no idea, right? They're just getting a check for $10,000 and putting their name to something that one of the communications firms in town has written. I do think they want changes. I think there was some speculation on the Innovation Alliance email listserv that this was Intel because they've got a big case that's going on. It seems like it's really centered on the FinTIV rule, which is about duplicative proceedings for the courts and the USPTO. I mean, I do think focusing on national security, we talk about this, of course, Bill. I'm not even talking to you because you know this already. You've heard my pitch, but I've talked to others. I mean, look, China is a centrally planned economy. They snap their fingers and they invest $50 billion in biotech, $50 billion in 5G, $50 billion in quantum computing, $50 billion in artificial intelligence, all the other areas where they don't want to just compete with us. They want to dominate because they think those areas are going to be critical for basically running the universe. They want to beat us for national security purposes, right? It's scary to think about it. But they can do that because that's the way their economy works. We don't operate that way. In the United States, we're a market economy. We have to have the right incentive structures so that private sector investment will flow into those areas. And to me, I've always thought the patent system was a key piece of that policy architecture. And when we screw this up, because the big tech companies of the world want to pad their already astronomical bottom lines, that seems very short-sighted to me. So I think talking about this issue, the patent system, in the context of national security, I think is the way to go. But I would just say one more thing. Anybody know the song Big Yellow Taxi? Joni Mitchell? You know what I'm talking about? Key line of that is, don't it always seem to go, you don't know what you got till it's gone. So here we are. I feel like we're almost too early, right? We're sort of raising the alarm, and it's not going to be until something horrible happens, some very dramatic event, that policymakers will say, gosh, I wish we had known about this. So that's my big fear, but I do think that this is the right context to talk about it.
Well, that's all the time we have. Thank you,
I
panelists.
filibustered, my apologies.
Gavel. Well, thank you, panelists from both panels, and thank you all for coming today and for this informative discussion. Thank you to our sponsors. In, let's see, 25 minutes, we'll meet upstairs at the atrium, which is main floor back, and that's where the reception will be, starting at 6, and then followed by the dinner at 7. Hope to see you all there.